Hi guys, it's Kathy. I hope you're doing well. I got a different one than what we're used to today. Um, the female attorney needs to learn to read the room. However, she's not wrong. And the judge sort of predetermines the outcome before he hears the evidence. And she calls him out for it. It's really good. But she really should learn to read the room. That's fine though. She does a great job for her client. Well, I don't know if it's her client or if she's the prosecutor. I don't know. It doesn't matter. It doesn't matter what the crime is. It doesn't matter what this guy did. None of that matters. It's just about the attorneys and the lawyer today. Let's see. There we are.
Testimony from a witness at a preliminary hearing based on failure for an expert disclosure when they weren't even due yet. So I think that objection in itself is not correct, and is not something that should be considered, but I'm trying to avoid that. And if we wanted, again, I have two questions for this witness at the preliminary hearing. And if I can ask those questions, I don't have to go through the expert endorsement at all. And the question, if they are either observations or they are not, the expert testimony isn't required under 1101. I simply want to ask, did you administer this test? And what did you see? And what were the results of the test? I mean, that's it. And so I really and truly don't think that at preliminary hearing, I mean, this is a Shrek hearing. This is what happens at trial. This is when you trot out all your experts, that sort of thing. That's something that is not the purpose of a preliminary hearing. I think the public defender's objection based on expert testimony in prior preliminary hearings has created a situation where preliminary hearings are turning into something that they shouldn't be, which is a mini trial.
So is it the people's position then, not to put words in your mouth, but that for purposes of a preliminary hearing context, there is no absolute requirement that a Shrek hearing be conducted in advance of anyone to be considered as an expert, even at a preliminary hearing, because the safeguard against whatever prejudice or problem that might pose for a defendant is cured by a traditional formal Shrek hearing in the context of a pretrial a hearing at which a trial expert is being offered, not a preliminary hearing expert.
Absolutely.
So all they're doing right now is talking about just the preliminary hearing and what they're allowed to do at the preliminary hearing. And it gets better when she gets up. Don't worry.
And if the court would allow the witness to testify as to the questions that I just asked, then I wouldn't even ask the magic words. I request that this defendant or this witness be endorsed as an expert, and then they wouldn't have that risk of, and I don't even think it's a risk, but they wouldn't have that concern, and it would simply just allow the preliminary hearing to be what it is, which is a screening device, not a mini trial, not a search for discovery, not something that needs to last, 2 hearings just to get to probable cause. So I think it's, if the court is willing to listen to that and allow that witness to testify to it, we don't even need to have this conversation right now. We can have it when it's more appropriate, which is after expert deadlines actually exist, because that's the other problem is, okay, we go through this Shrek hearing and then I get an expert deadline where I can submit different experts and we just do it all over again.
Right.
Your Honor, may I be heard?
Yes, ma'am.
Your Honor, I think there's a few different points that I have response to. I guess the first, the district attorney is arguing that the rules of evidence don't apply at preliminary hearings, and there just
I didn't hear that
isn't
question.
Case law that supports that. And in 18 years of doing this, I've never had a court hold that the rules of evidence don't apply at all. And I think that would be, for lack of a better term, chaos if we eliminated the rules of evidence from a preliminary hearing. I recognize that the language in 1101 is preliminary proceedings. I don't think those are necessarily talking about preliminary hearings specifically. And if the prosecution is going to argue that the rules of evidence never apply in preliminary hearings, I think that this issue needs to be briefed, because I don't know of any case that holds that none of the rules of evidence apply at a preliminary hearing ever. And I think that would be a drastic over reading of that rule. So that's first. Your Honor, the district attorney argues that the only reason that we're having this hearing is that I've objected to expert disclosures. It's not just the disclosures, it's the qualification. I do not believe that this officer is qualified to testify as an expert. And I will say that I would argue that the other reason that we're here is that the district attorney is seeking to admit expert testimony at a preliminary hearing, which I would argue is also not very common and unnecessary, which I've argued that before. I think that the officers can testify about their observation without being endorsed as experts. I don't think that it should be commonplace for officers to be endorsed and testify as experts. I think that that's a way to evade a lot of other rules and a lot of cross-examination. And my concern, Your Honor, is that if the court allows this witness to testify as an expert without going through the procedural foundation, the procedural rules and the foundation to qualify this person as an expert, that it waters down the whole process. Because future hearings, when the court talks about those safeguards being awarded at a future hearing, the problem is that at those future hearings, there's not a distinction between being qualified as an expert at preliminary hearing and being qualified as an expert for trial. There's the CV doesn't distinguish that. So it will look to a future court like the defendant or the court has, the defendant has received those procedural safeguards when in fact they haven't. There's not like a required asterisk. And my concern is that they will get kind of a credibility bump from receiving that, or from being able to testify as an expert without having to lay the proper foundation, that then will water down the procedural safeguards in the future. So Your Honor, again, this is not a matter of just notification. It's a matter of the witness being qualified. I think we're all on the same page of what the scope of the hearing is. Well, I guess with the exception that I do intend to ask about how he conducted the tests in this case. I think we can go forward with the Shrek hearing. I'm prepared to do so.
All right, Mr. Bema.
She's prepared, guys.
Endorse this witness. Would you like to inquire of the witness as to his expertise or lack thereof in the field of administration and interpretation of this type of a test, the HGN test?
Yep.
Okay.
Call Deputy Damian Evelis.
If you could just make your way over to the witness stand, please, Deputy. And sorry, it's a tight quarter. You probably are familiar with it. So first, do you swear or affirm under penalties of perjury that the testimony you're going to give today is the truth, the whole truth, and nothing but it? Sure. Okay, right. Thank you. Please be seated and be comfortable.
Okay. What's your current employment?
I'm a patrol deputy for the Seminole County Sheriff's Office.
And how long have you been employed?
Almost 5 years now.
Can you give me your general job description?
Respond to calls for service, conduct traffic stops, and just day-to-day things that we have going on in the county.
Did you go to the police academy?
Yes, sir.
What police academy did you go to?
That's going to be the Pueblo Community College in Mancos.
Can you repeat it? I'm sorry.
Pueblo Community College in Mancos.
Your Honor, just sorry to interrupt, but I realized I did not request a sequestration order. I don't see anybody else here, but I don't know if there are potential witnesses listening on live stream. So I would just ask for that formality that the court impose a sequestration order.
Any objection to that?
No.
Okay, so ordered.
Okay. You post certified?
Yes, sir.
What does that mean?
Went to academy for approximately 4 months and did training, read books, PowerPoints, had different instructors on different topics throughout academy.
Do you recall how many hours you spent for the entirety of the post?
It was over 500 hours.
And as part of your post training, did you get trained in SFST?
Yes.
What does FSST mean?
Standard field sobriety test.
And what are the SF? And if we refer to them as SFST, we're talking about standard field sobriety tests. What are the SFST tests?
So for the first one, we have a horizontal gaze nystagmus, which is the involuntary jerking of the eyes. And it's 3 different tests for the eyes. The first one is lack of smooth pursuit. Second one is maximum nystagmus and maximum deviation. And the third test is the onset of nystagmus prior to 45 degrees.
Okay, so you spoke there, and we are going to refer to, if I say the words HGN test, will you understand what that means?
Yes, horizontal gaze nystagmus.
Okay, say that again.
Horizontal gaze nystagmus.
Okay, and were you trained on how to perform the HGN test?
Yes.
What did that training entail?
It entailed reading books, PowerPoints, and we had to do tests on our peers in the academy.
Where did you receive that training?
It was that training we did in Durango.
And what do you remember what the name of the school was?
I think that one was, we conducted the SFSTs at the Durango Police Department or La Plata County.
What year did you get that training?
2020.
Was that part of your post certification?
Yes, sir.
How many hours in general did you spend on SFST? Let me ask a better question. How many hours did you spend on the SFST training at the post certification?
It was over 30 hours.
And when you were at that training, did you actually practice carrying out the HGN test?
Yes, and we had an instructor with us the entirety of the time.
Okay, and did an instructor observe how you carried out the HGN test?
Yes, sir.
And what was the result of that?
It passed.
Did you also have to take any other type of test as it concerns the HGN?
Yes, we had to take a written exam.
And what was the result of that?
I passed.
And again, the instructor observed your...
Some of them would have to be drunk, right? I'm thinking that that the police got drunk for the test.
Your carrying out of that test at post, right?
Yes, sir.
Were you trained on how to interpret the test results?
Yes, sir.
What did the training for interpretation of the HGN test entail?
It's the involuntary jerking of the eyes.
And where did that training occur?
That also occurred at the same location where we trained the SFSCs.
So your training and education on the HGN test for both administration and interpretation took place at the post training. Is that right?
Yes, sir.
And did you actually have to? Let me back up. Did an instructor watch you both take the test and how you interpreted those results?
Yes, sir.
And how did that? Did you pass that?
Yes, sir.
Approximately how many times have you conducted the HGN test after that training?
Roughly around 30 to 40 times or more.
And have you ever been recertified for carrying out SFSTs in general?
Yes, 2 times.
Is that in both of those recertifications, was HGN included in that training?
Yes, sir.
And what does recertification entail?
It's also going to be the same. It's going to be a written exam, PowerPoints, and do a test on peers as an instructor watches you.
And when was the last time that you were certified?
Recertified last week.
And who trained you on that?
Corporal Wilkerson.
And did he go through and watch how you conducted the HGN test?
Yes, sir.
And did you pass?
Yes, sir.
And did he also observe how you interpreted the HGN test?
Yes, sir.
And did you pass that?
Yes, sir.
And so you got recertified.
Yes, sir.
Is the HGN test a standard test?
Yes.
So what does that mean to you?
It's usually the first test we do, and it's got the highest probability rate for someone consuming alcohol.
And what is the purpose of the HGN test?
It's to see how much, it's not to see how much, it's to see the involuntary jerk in the eyes, like I mentioned before. And this is sorry, is that what you meant?
Yeah, that answers that question. But what is the HGN test? What are the results of an HGN test? What are they helpful for?
So when people consume alcohol, they get involuntary jerk in the eyes, and we've had a pretty high rate on that. With once we conduct that test, and we do our either breath test or blood test, they're usually above the 0.08 level.
Holy shit, Fossey, how can you even see chat with your eyes jerking around like that?
And how do you carry out the HGN test?
So for the first test, it's going to be a lack of smooth pursuit, which is you get your stimulus 12 to 15 inches away from the person's face, above the eyebrows, and you go out for 2 seconds out, 2 seconds in on both eyes. And the second test is a maximum deviation, which you hold your stimulus same position. You hold it for 4 seconds out, 4 seconds in. And the third test is the onset of nystagmus and prior to 45 degrees, which you move at a lower pace prior to 45 degrees and looking for jerking of the eyes.
And so how many clues are there? Let me back up. What does a clue mean when you're conducting SFSTs?
It's going to be the jerking of the eyes, and you get one clue for each eye for each test.
For a total of how many?
6.
Do you have specialized training in conducting the HGN test?
Yes.
Do you have specialized training in interpreting the HGN test?
Yes.
And what is that?
It's going to be conducting the test and looking for the clues, which is obviously the involuntary jerking of the eyes.
Well, what is the training?
The training.
And I know you kind of already went over this, but just to summarize, what is the training?
So the training is to just,
We get into that when she gets up. When she gets up, it's great.
I said it's the lack of smooth pursuit, onset of maximum deviation, onset of prior to 45 degrees.
But again, did you go to some classes?
Yes, I went to classes and conducted tests and tested my peers.
And do you have knowledge concerning the HGN test, conducting the test?
Yes.
And do you have knowledge in interpreting the HGN test?
Yes.
And do you have skill in conducting that test? Just let me finish. Sorry. And do you have skill in interpreting that test?
Yes.
And do you have education in conducting that test?
Yes.
And do you have education in interpreting that test?
Yes.
So, Your Honor, at this point, for the purposes of the preliminary hearing and knowing that expert disclosures are not yet due,
Excuse me.
but at this point, we would move to admit Deputy Neeblis as an expert in conducting the HGN test and interpreting the HGN test results.
I have what are your questions, Your Honor?
Yes, please proceed, ma'am. Thank you, Mr. Freeman.
Do you need some water?
Yeah, that'd be great.
Mind if I go grab him some water?
Not at all.
It'll take me just a couple of minutes because I need to.
There might be some bottles of water in the back storage room too. I think we need at least 2. Did you want one, Ms. Gunn? Okay.
Do you want me to start or wait for the water?
Miss Khan, I think, is the lady who got pulled over for DUI, but I don't know that because we don't even get into her at all or her case.
Good either way.
Why don't we just wait? That's
Okay.
It
Yep.
sounds like it'll only take a second. They're good.
Should be easy to find, or I can go find it for him. The road to the left. No? Oh, Brian, Mr. Young is gonna. Okay.
Do you want some water?
So go ahead.
Oh, we don't have water?
Okay.
Oh,
So Deputy Needless, am I saying that right?
Yeah.
Okay. I just kind of want to start from your CV here. So we've heard about it. Thank you. I appreciate it. We've heard about the post certification. I guess, where did you go to school?
it's going to be the Pelican Community College in Mancos.
Okay. Did you go to school before that as well?
Oh, sorry, for high school. Yes,
And where did you go to high school?
Norwood High School.
Okay. And then, so you said that you got your post certification in 2020. Is that right?
Yes.
Okay. So I want to talk a little bit about the post certification. So you testified that the post certification was 500 something hours, right?
Yes, ma'am.
Do you know what percentage of that was on standardized field sobriety tests?
It was over 30 hours.
Okay. And then you testified that you have been certified a couple of times since then. Is that right?
Yes, ma'am.
Can you tell us when those certifications were?
The next one was in 2022, and then just last week.
Okay. And just to be clear, you were certified just last week. Fair to say you knew at the time that you would be testifying today. Is that right?
No, we just had a class and we ended up going.
You didn't know that you would be testifying today when you did that class last week?
I actually didn't even realize till last night I was going to be here today.
Okay. Well, you had been here before, right?
What's that?
You had been here before. Is that right? On this
Not in
case?
the court.
Okay. Fair to say that certification was after the test that you did in this case. Is that right?
Yes, ma'am.
Okay. And then before the test that you did in this case, and we'll be clear, the test that you did in this case, Ms. Gann's case, was on October 31st of 2024. Is that right?
Yes, ma'am.
Okay. And so before that day, you hadn't been certified. It had been since 2022 that you were certified.
Yes, ma'am.
Okay. And then when you were certified in 2022, what did that certification entail?
The practice of SFSTs again and PowerPoints and testing.
Okay, how many hours was that training?
This is. I'm unsure about that one because I was still certified on that one. So
Was it like a one-day thing?
yeah,
Okay. So it wasn't multiple days.
no.
Okay. And just I'll try to do this too, but we need to be careful not to answer at the same time or question each other at the same time because all of this is recorded and it's really hard to parse out when we're all talking over each other. So I'll try to be good about that too. Okay, so your prior certification was
The people is not good at that.
something like a one-day situation. And in your prior certification in 2022 specifically, did you also address multiple roadsides?
No, ma'am.
You only addressed the HGN?
Sorry. So
I'll ask a more clear question. In that prior certification, did you cover more than one type of test?
Oh, yes, ma'am.
Okay.
Yeah.
So not just the HGN test? No. Okay. And what were the other tests that you covered?
It's the one leg stand and the walk and turn.
Okay. And then in your post certification, were those the two other tests that you covered as well?
Yes, ma'am.
Or did you cover any other types of tests? of standardized field sobriety tests specifically?
No, ma'am.
Okay. Now, Deputy Needless, you testified that you have done, well, and I want to clarify, you testified that you have done about 30 tests, and did you mean that you had previously done 30 standardized field sobriety tests generally, or HGN specific?
Generally.
Okay. With respect to HGN, how many times have you, prior to October 31st of 2024, had you performed that test?
This is about the same number.
30
to 40.
Okay. Is that something that you keep track of?
No, ma'am.
Okay. How did you arrive at that number today?
You can kind of see it, but I mean, that's usually.
Ms. Gann, did you need a break? Okay. Your Honor, could we just break for just a couple moments?
Okay, we can go off the record for a few moments while the defendant uses the restroom.
You can get up and walk around.
She just got up and left.
You can get up and walk around.
Fletcher, thank you so much. I appreciate it. He looks like he's trying to do the walk and turn. So now we're doing Jim in the courtroom. She just got up and left in the middle of court. That's what I want to do someday.
Okay. You don't recall that section of the manual?
No, ma'am.
Okay. And none of your superiors have ever told you that that's a good idea?
I'm taking a guess here. Fozzie's dog. Nah, doesn't Sierra sleep with your daughter?
Objection. This is, again, getting into whether this question is, are you an expert on this manual? We haven't endorsed him as an expert on the manual.
I mean, but
Endorsed him as an HGN expert.
But they have, though, because it's based on based on this training.
It's not based exclusively on that. It's based on his entirety of his training experience and everything. It's not, that manual is not the only thing that makes him an expert. And he is not an expert in that manual.
So noted. Is that manual then the manual for recertification then? I mean, are you talking about these post-qualifications requirement of keeping a log or best practice, not necessarily requirement? I don't know what the right way to say that. Are you saying that then he would not have otherwise been eligible for recertification if he hadn't maintained such logs? Because it sounds like we've now had 3 data points of qualification as an expert, particularly in both administration and interpretation, but you're highlighting something that might have been missed by the instructor that qualified him or requalified him?
Your Honor, I'm not saying that not using this log necessarily would be a thing that would not certify him, but I am arguing that this is important for the court's consideration when the court is considering whether he is practicing consistent with what his training is. And the court has heard him say that he has performed the test 30 times, and the district attorney has argued that his expertise is based on his experience. And part of the issue is that this experience doesn't make him as an expert if the experience is not right, if the experience is not accurate. So I have a couple more questions on this, and then I will move to the HGN.
Well, that might be your hypothesis, but okay, go ahead. Ask your questions, please, quickly.
Okay. This is the point where she should read the room. He just gave her what he, as the judge, is thinking. She ignores it.
Okay. And Deputy Bliss, so you said that you don't recall the manual telling you
Tanya. Thank you,
that
thank you.
the use of a field arrest log is strongly recommended.
Asked and answered.
No, ma'am.
Okay.
Yeah, he's answered it, so sustained.
Your Honor, if I would reviewing a section from that manual refresh your recollection.
Objection relevance.
Yeah, why is it relevant? You've already established that it's part of this manual, but you've also admitted it doesn't necessarily disqualify one as an expert if one hasn't maintained such a log.
But he hasn't testified that it's part of the manual. I can't testify to that. He has to. So
He's not endorsed to testify about what that manual does or does not say.
All he can do is what he did, and that's recognize the cover page and flipping through it real briefly, but you're now picking and focusing on one particular page out of hundreds.
yes, and I can do that. Your Honor, again, I think that please don't interrupt me. I think again, it's
relevant
just not
because-
accurate. It's just not accurate to say that he's not endorsed as an expert on this manual. This is the basis for his expertise. So asking him about the manual, he has testified that this is what he was trained on and this is what is the basis for his qualifications. So I am asking him if reviewing a section of the manual would refresh his recollection because he is saying he doesn't remember the manual telling him that. So I'm permitted to refresh his recollection, frankly, with anything, particularly things that he's familiar with. So I'd ask to approach to do so.
And what you're approaching with is this field arrest log slide or
This,
page?
yes, this slide, and I'm happy to show it to the district attorney.
All right, you can approach him. I don't know necessarily what relevance it has in terms of his qualification as the expert, but he can look at it again and
She's going to choke slam the judge soon because he is dismissing her evidence before she even puts it on.
acknowledge that it's part of such a manual.
Well, I hope the court will, the court certainly at the conclusion of the hearing can determine what weight the court gives the evidence, but I hope the court will listen to the evidence that I present before determining whether the court will find the information useful.
Oh, Judge, you hear what she just said to you? Yeah, you do have to listen to the evidence first, Judge.
That's fine with me. That's why I said I'd give you latitude, and I respect the people's right to object, but here we are. You need the page. It's sitting next to Mr. Bama. Or don't. Oh, okay.
It's a copy of this. Deputy Nicholas, do you recognize that?
Am I looking at this one?
You're looking at the page on the left?
I don't really remember that.
Okay. Does that look like one of the slides that you were trained on?
I don't remember seeing that.
Okay. So you don't remember seeing a slide that said that it is strongly recommended that you keep one of the logs?
No, ma'am.
Okay. Do you think that you were not trained on that?
Objection. Not endorsed as an expert on what the training is or is not entailing from this manual. I mean, she's cross-examining on questions like that a trainer would maybe be an expert on, maybe, but he's not the trainer. He's been trained. That makes him an expert. That's all that we need to do. So,
Dude, you brought this man in as an expert. You did. You say he's an expert.
questions about whether or not it's best practices, and that's not what he's been endorsed to testify about.
I'm asking him questions about specific things that he was trained on. If he is testifying, please don't interrupt me. If he is testifying about things he was trained on, and yet he's not familiar with the whole manual, I think that the court can consider whether or not he, in fact, is an expert in that he's been properly trained and is in you acting consistently with his training. That's what, I mean, this manual is what he said that he was trained on.
Okay, I'll overrule the objection, but note the people's notation or insertion that this gentleman is not an expert on the manual itself. And so go ahead. And you yourself said this is a recommended practice.
Strongly recommended.
Strongly recommended practice. Okay.
Okay. Do you think that you were not trained on that section?
Sorry, are we talking about academy still? Or
Yes.
We might have been. I mean,
Okay.
we most likely were, I'm guessing.
Okay. Do you think you were trained on that at any of your other trainings?
I have not seen that since. My last training was a newer version of this, so
Okay. Your last training.
last week.
Your last training was a newer version of the manual?
Yes.
Okay. Did you look through the manual?
No, he put it on a PowerPoint.
Okay. Do you know what version it was?
It was the 2023, I believe.
Okay.
Colorado.
Fair to say that. Okay. Is your testimony that that section wasn't in the manual?
Objection, foundation. It has nothing to do with his endorsement.
He just testified that he was trained on a new manual. I'm asking him about a manual that he was trained on.
Well, he identified
Memorized
a version, but I don't, short of a photographic memory and the ability to go through hundreds and hundreds of pages in each of the two separate editions, I'm not sure.
Yeah, but he's brought forth as an expert. He's not brought forth as someone, an officer that did the field sobriety test. No, he put him on the stand that says he is an expert at this, an expert witness.
What the sense of the question is. You can ask him if he remembers seeing the same recommendation in the latest version that he was trained on, I suppose.
Okay. I would ask him to answer that question that the court posed.
Yeah, ma'am.
Okay. You want to approach to retrieve the manual?
Sure.
Okay. Now, Deputy Nebus, let's move to the horizontal gaze nystagmus test specifically.
I don't know if ice cream does melt. It's never been around long enough for me to know.
Now, Deputy Nebus, one of the things that you undoubtedly learned in your training is that nystagmus can come from other things besides alcohol use. Is that right?
Yes, ma'am.
And that does include drug use, right?
Yes, ma'am.
But it also includes medication use.
Yes, ma'am.
It also includes medical conditions.
Yes, ma'am.
It also includes things like head injuries
Yes, ma'am.
and other injuries.
Yes, ma'am.
And in order for the HGN test to be reliable, as you testified to on direct examination, there are certain things that you have to rule out before drawing your conclusions. Is that right?
Yes, ma'am.
So there's part of the procedure is that there's questions that you ask the person before conducting the test.
Yes, ma'am.
And some of the questions that you ask are things related to medical conditions, right?
Yes, ma'am.
And you ask them if they're under a doctor's care,
Yes, ma'am.
if they have certain medical conditions.
Yes, ma'am.
You ask them if they have any, do you ask them if they're on any medication?
Yes, ma'am.
Do you ask them if they're on any medication before you do the test?
Yes, ma'am.
You ask them if they have things like head injuries, right?
Yes, ma'am.
Or if they've suffered any other injuries recently.
Yes, ma'am.
Okay. What questions do you typically ask when you do an HDN? What are your questions that you ask the person before conducting the test?
I've never seen
If
it.
they've been hit in the head lately, if they're wearing glasses or contacts, are they under the care of a doctor or dentist? And obviously if they've consumed any alcohol and or drugs.
Okay. Do you ask them?
This is cross-examination, so on cross you can lead.
I know you said that you ask them if they have any glasses or contacts. Do you ask them if they're under the care of an eye doctor?
No.
Okay.
Well, I mean, if they have glasses or contacts in
Would you agree that there are some eye conditions that don't necessarily require glasses or contacts?
it, I'm not sure.
Okay. Would you agree that a person could be under the care of a doctor and not require glasses?
Yes.
Okay. And not require contacts?
Yes.
Okay. Do you ask them if they are under the care of an eye doctor typically?
No.
Okay. And you are aware that there are some people that have things like resting nystagmus. Is that right?
Yes, ma'am.
What's resting nystagmus?
Involuntary jerking of the eyes.
Okay. And the term resting, what does that refer to?
What's that? Involuntary jerking of the eyes?
Sorry?
Sorry, can you repeat your question?
When we say resting nystagmus versus any other kind of nystagmus, what does that signify?
So if you're not moving your eyes, but they're still shaking,
So
jerking,
in other words, nystagmus even when the eyes aren't moving one direction or the other.
you could, yes, ma'am. You can still have it.
Okay. And do you ask them questions to determine whether they have any conditions that would cause that kind of nystagmus?
Yes, I have them if they've been seen. I guess I do. I asked them if they've been seen by an eye doctor and if they've been told they have resting nystagmus.
Okay. What if they don't know what nystagmus means?
Objection calls for speculation beyond the scope of
I'll sustain that.
opinion.
Your Honor, I'm asking about how he conducts the tests. If he's testifying that he is an expert in how to conduct the tests, then I think when someone is unable to answer the questions that are required to eliminate natural causes of nystagmus as a potential explanation, he should be able to explain how he does that.
But haven't you already asked him what the menu of questions that he asks and thus how he's doing it? I thought
Yes.
you covered.
But this is still under that umbrella. I'm asking him about the questions that he asks. So he says that he asks them if they have any resting nystagmus. And so I'm asking him what he does if they don't understand the question, how he gets that information that he needs to rule out other causes of nystagmus if they don't know what nystagmus means.
Objection, speculation. It sounds like this is a hypothetical at best, and I don't know if there is training that would endorse that. Somebody says, I
don't know what nystagmus means.
It assumes that occurred, but I'm not necessarily sure that that's something that training would address.
Well, all of the things that we're talking about right now are speculation. I'm asking him the question because he can tell us what he does. That's what we're talking about, what he does. So it's not speculation. It's asking him what he does. And if he's going to testify about how he does the tests, I'm asking him about how he does the tests.
Haven't we already established that he asks whether they have resting nystagmus or whatever? And then you're positing a situation when the person just happens not to understand what the meaning of that particular word is. Are you asking him whether he then explains to them it means such a condition, or? Yeah,
I guess I can reform my question, and reforming it would be, how do you get that information if the person does not know what nystagmus means? I can ask that question. That's what I was trying to ask, but I can ask it that way because I think that we do need to know how he eliminates other causes of nystagmus other than impairment if the person can't answer the question.
I think that's asked and answered, I think.
Oh, but he hasn't answered it. We've been arguing about it.
What didn't you ask him before whether he asks about resting nystagmus?
Yes, and he
said yes.
Right.
Okay, he's nodding yes. All right.
Right, but so the next question is, if the person does not know what nystagmus is, how do you get that information?
Is that part of the expertise?
Yes.
The training or the manual? Is that what you're implying?
Well, what it is, Your Honor, and he's testified to this, is that there's a host of different things that cause nystagmus besides impairment. And he has to.
So this is still voir dire. She's just asking questions of this witness to make sure he's an expert. That's her job. Her job is to question this witness to see how much of an expert he is, and then the judge is supposed to decide if he's an expert or not.
Eliminate those other things in order for him to interpret the test as a reliable test, as he's testified to. So,
How would he know what the other person does or does not know?
It would have to be verbalized, wouldn't it?
but I think right now we are speculating about how he would do it. I'm trying to ask him how he does it.
So is the question not if the subject verbalizes confusion or lack of understanding about what nystagmus is, how do you respond, Deputy?
Yes.
Is that fair? Okay.
That's fair. That's
Let's
fine.
ask that.
Okay. If a person tells you that they don't know what nystagmus means, how do you get that information?
Just, I advise them it's the involuntary jerking of the eyes, or most likely they don't have it because they haven't seen a doctor and been told that, an eye doctor and been told that.
Okay, so I hear you say most likely they don't have it, but do you make that assumption?
Yes.
Okay, you don't just ask them? You make that assumption, you don't just ask them?
Objection. I think that misstates his testimony. He testified that he does ask.
He did testify that he does ask them if they have resting nystagmus.
Yes.
Did you not?
Yes.
Okay.
That wasn't the question that I was referring to. So I guess let me ask it again. So you just testified that if a person tells you they don't know what nystagmus is, how do you get that information? And you said, I tell them it's an involuntary jerking of the eyes, or I assume that they don't have it. Is that what you tell them?
Yes.
Or what your answer is?
Yes.
Okay. And then I asked you, you assume that they don't have it. Is that right?
That's what I tell them. So
You tell them that you assume they don't have it?
tell them, so you probably don't have it due to, you haven't seen an eye doctor.
Okay. So my question is about your answer that says you probably don't have it.
Mm-hmm.
What tells you that you should come to that conclusion?
I mean, if you have resting nystagmus, you've probably seen an eye doctor once in your life and you probably have it.
Okay. So I'm hearing a lot of probablys. What do you actually ask them? Like, what information do you actually get out of them to come to that conclusion?
If they have resting nystagmus.
Right. But we've already established that in this scenario, the person has told you that they don't know what resting nystagmus means. Right?
Yes.
Okay. So what information do you ask them when they tell you they don't know what that means?
They probably don't have it, or
Is that what you ask them, that they probably don't have it? I'm asking you.
yeah, that's what I tell them, that, or yeah, they probably don't have it, or yeah.
Okay. So if they tell you that they don't know what resting nystagmus means, you come to the conclusion that they probably don't have it.
Objection. Misstates testimony. Asked and answered.
Yeah, he's already answered the question.
I don't think that he has, because I asked him what he asked them, and he said they probably don't have it, which isn't a question. So I'm clarifying that essentially he doesn't ask them any other questions, which I don't think has been asked and answered.
But I thought the point of the line of questioning was, in order to make a determination of whether the subject would have resting nystagmus, this officer, if confronted with the response, I don't know what nystagmus is, then this officer responds as a matter of, course, it's involuntary jerking of the eyes. And then are you saying that the subject then doesn't know what that is either?
Well, let me ask this question. Deputy Neblis, when someone tells you that they don't know what nystagmus means, do you Do you always explain it to them?
Not always.
Okay. Do you respond that they probably don't have it?
Yes.
Where did that come from in your training?
Nowhere.
Okay. Deputy Needless, when someone tells you that they don't know what nystagmus means, do you ask any other questions to eliminate? Let me rephrase the question. Okay, let me move to a different question. So, Deputy, is it fair to say that you haven't ever testified as an expert before? Is that right?
That's correct.
Okay, you haven't ever been qualified before a court as an expert?
No, ma'am.
Have you testified about HGN before?
No, ma'am.
Okay.
Deputy, how are you liking your first time?
Your Honor, I would like to ask him some questions about what he did in this case for the reasons that I've stated, which are that I believe that part of the assessment about whether he's an expert here, whether this is useful to the court here, is whether he completed the assessment correctly. So I am moving to that portion.
And I object, and I guess it is probably a good time to get to the ruling again. Whether or not an expert is using the reliable scientific purposes that he's trained on goes to weight and not admissibility, and can always be mitigated by vigorous cross-examination. Just because you disagree with how somebody did something doesn't mean that they're not an expert in what they're doing. And then again, this People v. Ambrose, 506 P 3rd 57, 67 or 69 through 70, Colorado Act 2021. Again, any concerns about what techniques were followed can be mitigated by vigorous cross-examination, which is where this is about to clearly go. And that is not part of the expert analysis. That is trial. So the goal, 702, is reliability, not certainty. And even if there are other ways to do it or better ways to do it, that is not good grounds to keep an expert from being qualified as an expert.
Judge, you can't say he's not qualified because her questions are showing that he's not qualified as an expert. It's not fair. You can do that in trial, but this is the preliminary hearing.
Do you want to respond to that?
Yes, Your Honor. First, Your Honor, I certainly would argue that he's not qualified to testify as an expert here. He has testified that he's not familiar with portions of the manual, that he's not following the recommended practices, but also that he's not taking the steps that he needs to take to rule out other causes of nystagmus. And I think that that's a pretty significant portion, that the questions that he asked before he starts the test are to rule out other naturally existing or other causes of naturally existing nystagmus. And he is, rather than asking questions to rule those out, he is jumping to conclusions and making assumptions that are not based in his training. Your Honor, I would, as an offer of proof, I would let the court know that that's what happened here, and that I would expect that his testimony about how he conducted the HGN here would be consistent with what my argument is, that he's not doing the test correctly and to rule out naturally existing nystagmus, and therefore not only is he not qualified, but his testimony is not admissible in this hearing, in the preliminary hearing, and as an expert moving forward.
Well, my view of this is that, I'm going to make a finding that based on the direct testimony here, that this officer has substantiated that on no less than 3 occasions in 2020, 2022, and recently, as of last week in 2025, he was qualified as an expert in the administration of the HGN testing protocol, as well as trained in its interpretation. That this certification was based on a third-party trainer administering both a practical and a written exam. That's the direct testimony that we heard, thus qualifying him as an expert. And it seems to the court then that the line of questioning that was most recently pursued as to whether he's asking the full menu of questions or whether he's providing adequate explanation goes more to disqualifying perhaps his administration on this occasion with this defendant, rather than decertifying him or disqualifying him as an expert, because the third-party trainers are the ones that are ultimately responsible for the qualifications. And I've heard that on at least 3 occasions, he's been certified as an expert, both in the administration as well as in the interpretation. And nothing that you might bring up today as to the facts and circumstances surrounding this test is determinative of him not being an expert, because his qualification as an expert is established through the direct testimony that we've heard. I appreciate you take issue with how he administered his test and what he might not recall from the protocol, but that's not relevant to him being qualified or not qualified as an expert. Now, he might have committed malpractice, like someone else, for example, a doctor who could be very qualified and pass whatever medical boards, but then on one occasion or a number of occasions didn't practice correctly. That's a possibility here. But that doesn't mean that that doctor is D board certified or has his license revoked as a qualified physician, that being just an analog that I would posit as an explanation for the finding that I've made that he does qualify as an expert in these 2 areas. And therefore, the utility of presenting more detail as to what the conduct of this particular test on this particular defendant doesn't undermine the third-party certifications that we referred to.
Your Honor, may I respond?
Yes.
I do want to draw a distinction because I think what I hear the court saying is that questions about what he did here, whether he followed his training here, wouldn't decertify him. And I just want to bring us to what we're here for today, because there is a distinction between whether he's taken a test or possesses some certification, and whether that remains with him forever, or moving forward in the outside of court world. And then there's a distinction between that and whether he's qualified to be an expert in this case. So the court does have to look at whether or not he's qualified to be an expert in this case. And I think there's also a distinction between whether a tester or an examiner has labeled him an expert, because that's not a legal conclusion. And I would also argue that it's not a certification that per se provides expert qualification. The court determines whether someone is qualified as an expert, and whether someone has taken a test does not result in a per se qualification as an expert, particularly if they're not using that testing, that education in practice. So the court does have to look at what happened here, and whether the officer, regardless of what the training was, whether they're acting consistently with that training to determine if they can testify as an expert here in this case. What the court does here in this case doesn't undo testing in the past, and I'm not arguing that, but the law doesn't require a showing of that or require a result that dictates that.
Are you saying, though, my finding was that based on third-party examinations of this individual in 2020, 2022, and 2025, both in the form of practical examinations as well as written examinations, that it was the direct testimony that's not rebutted, unless you haven't gotten there yet, that he passed these tests. And so therefore, the court will then make a finding that based on these qualified police trainers in examinations of him as both an expert in administration of the test as well as interpretation of the results of the test, there's no better basis that any court could have, unless you're telling me that these trainers have been, they've somehow been also decertified as qualified trainers to test and evaluate.
Well, I guess the court certainly can disagree with. The court has the ability to assess the evidence. However, the court decides to assess the evidence. I would argue that it's not. It has been rebutted, because regardless of what any certification is, if that's not what he's doing, then he's not an expert. And so the testimony today has been that for whatever reason, if he doesn't, I don't know if he doesn't remember the testing or remember what he learned in training, or if he just disregards what he learned in training, but that's not what he's doing. So if a person takes the bar exam and suffers from amnesia the very next day, they're not an expert in law because they passed the bar exam the day before. The question is, what is happening that day? And so here, regardless of whether he passed a test several years ago in 2022 and in 2020, which is the most recent testing to this case, he's not doing that now. So I think that the court does have to look at.
Not if he can't remember if logs were covered in training, and he just assumes that they don't have it if they don't know what it means. No, I would not hire him as an expert. I wouldn't.
What he's actually doing to determine whether he's an expert.
Well, you're drawing a conclusion that he's not ever done it. You've highlighted, you've made a record of certain, perhaps lack of the full roster of questioning, or perhaps lack of keeping of certain logs that are strongly recommended that you've said in that manual. But you've made that record with respect to this case, but what cuts against that decertifying him or making him profoundly not qualified to be an expert is the fact that just a week ago he was recertified. Presumably these principles aren't ever shifting, and so therefore it would have been the same responsibilities he would have had in the 2018 manual version that he would have needed to have demonstrated or been competent in, or met the minimum requirement for to be at least recertified in 2022. And clearly he was recertified last week. So what I think the People v. Ambrose remedy is really what, that's the relevant principle here. The court just makes this initial inquiry and finding and determination that this individual has been duly certified or recognized and trained as an expert in this. And then obviously the cross-examination can help dissuade the trier of fact of.
We don't know because she got interrupted at that point.
His expert the application in this context here, and you're free to do that, and you've already started it. It sounds like, or it seems to this court, but just for the threshold inquiry, which is all we're really doing here, may this man testify as an expert or not? I'm finding that based on these third-party testing procedures that at least circa 2022 that preceded this particular event, that yes, he was and should be regarded as an expert, notwithstanding any failures he might have made in the context of his encounter with this particular defendant.
Yes, Your Honor. I understand the court's ruling. Your Honor, I do have a request with respect to discovery, particularly given how much the court has relied on the certifications for the court's ruling. We are asking that we be provided with that testing, with the test results, with the information about that certification. I kind of talked about this at the last hearing, but I think that wasn't finally one of the things that we landed on as far as what would be required. And I understand that. But particularly given how important that is to the court, I do think that it is a fair request for the defense to be provided with that information. So whether that be the court order that be provided to us through discovery, or whether the court set a subpoena ducis tecum return date, we will be asking that information be provided to us.
They did not. This is a preliminary hearing. They could have just put him on the stand and asked their questions. Did you conduct the field sobriety tests, and what were the results? They could have just done that. They put him on as an expert, and now she wants his test results.
And so unless there's anything else, we would ask that the court order that, but then we can move to the preliminary hearing.
Well, let me just also, picking up on that thread, because back on January 10th, 2025, you did indeed inform the court that you had 3 specific things that you wanted to know. The first was the version of the NTSA manual that was used in his SFST program, which someone uttered at that time 2020. So that's maybe not even consistent with the 2018.
I think the training was in 2020.
Yeah.
I think based on what we just went through here today, the 2018.
So there's a stipulation that 2018 manual was the one then, so that answers and is responsive to the prior question. Is that right?
And just,
you
Your
get
Honor,
all the information you requested.
I think, and I'm not arguing that the district attorney didn't, we've had a conversation about what would be provided prior to today's date. And I do think that the district attorney attempted to get that information. So I'm not saying that that the district attorney failed to comply with that or anything like that. What I'm saying is we are asking for this certification, information, test results, tests, what the certification was and what the materials were, in light of the court's emphasis on those certifications today. So I don't know that we need to go through what the prior conversation is. I'm not arguing that there was some violation of the prior conversation.
Okay.
So can I just to make a record on the certification? I don't know. I had no idea, but I would just like to ask him what. And so let me,
yeah, I don't ask. Yes, please go right ahead then.
So as it concerns the certification, do you have those records? Like, do those records exist?
Yeah, they should.
Okay, what are they? Just so we know what to look for and what to produce.
Probably.
What are the tests?
Yeah, like what can you get me that evidences your certification?
I'm not sure, because I mean that goes straight up to them, and then we just put it on their CBA, and that's the hours and stuff. So
in other words, you don't have like a binder with your certifications in it.
Oh, I have my. Oh, sorry. Yes, yes, I have my certification.
So you do. You have like your certification.
Yes.
Okay. So you need to get those to me.
Okay.
Okay.
Yep.
And then.
Oh, shit, guys! He's an expert. He is an absolute expert, guys. He has a binder. That's where she messed up. She didn't ask him if he had a whole bunch of binders, and he does. Yep, she lost.
You're certified now.
Yes.
How long did the certifications last?
They expire every 2 years. You have to recert every 2 years. Sorry.
So you're certified in 2020.
2022.
And then did that expire at some point?
Not that one. The one after 2022 did.
Okay. When did that? Do you know when that one expired? Off the top of your head?
I don't.
You have to look at your certifications. Yeah. And then you got recertified a couple weeks ago.
Yeah, last week.
Okay. But you don't know whether or not you were. Do you know the time frame?
The time frame?
Yeah.
I don't.
Okay. But you can look at those records and find out.
Yeah, I can find out.
Okay.
Did you say though that your certification expires every 2 years?
You have to recertify every 2 years.
Okay.
He went 3 years.
Okay. I guess the relevant dates will be teased out.
Because he got it in 2024. I mean, he didn't get it in 2024. He got it in 2020, 2022, and then in 2025.
Well, let me ask. I mean, we might as well. I mean, were you certified at the time of this stop?
No, he wasn't certified at the time of the stop, was he? Because that was October 2024. There's a slim chance he was certified.
No.
Okay, but you are certified now.
Yes.
He was not
All right.
certified.
And so, and certification is something that you redo. And did you have to actually get more training because of the?
Because of the lapse, yes. Yeah, it was a longer, more hours.
Okay. All right. And so just to close, we can get those certifications that show the dates though.
Yes.
Okay. And so get those.
Okay.
Okay.
Okay, so then for this, did you want to respond?
I just would ask that the court consider its prior ruling, given his testimony that he wasn't certified at the time of this stop, because again, we're talking about a test that he did in this case, and whether he's qualified as an expert in this to interpret in this case. So he has testified that he wasn't in fact certified at the time that he conducted the test in this case. We would ask the court to not qualify him as an expert. The court heavily relied on those certifications in making its ruling. I think the court now has new information.
Based on this new information, okay, Deputy, let me just ask you directly for the record. On October 31st, 2024, were you certified as an expert in both the administration and the interpretation of this HGN test?
I was not certified then.
All right.
My argument is that he was certified prior. He has the experience. He has the knowledge. He has the specialized skill. That doesn't go away just because a piece of paper, quote unquote, lapse. And I think that you look at it from today's perspective when he's testifying today. And I think that is actually what the law says is when you look at the expert's qualifications, when he's testifying, and that is what actually determines.
What purpose would I'm sorry, I didn't mean to interrupt you. What purpose would a or a lapse have other than decertification then of someone as an expert in the particular subject matter?
I don't know. I think that's probably a better question for him.
Okay, could you answer that question?
Yeah, sorry, can you repeat that? I'm sorry.
So what purpose would this 2-year expiration period, this rolling 2-year, or good only for 2 years, what purpose would the expiration of a 2-year period have after you've been qualified as an expert have other than to decertify you as an expert?
And Your Honor, I guess I would object to that based on ask for speculation. I understand that why the court wants to have that information. I don't know how you would know that.
Well, he would know what the standard in law enforcement is. I certainly don't.
Well, I think that the certifying, the people who do the certifying would know that, but I don't know that he has a foundation for knowing that.
Well, as Ms. Apatow aptly points out, the court relied heavily on the fact that there were these milestones of testing, both practical testing as well as written testing.
I'm not certified, but I'm close. I'm certifiable.
And if there is a protocol in the law enforcement world that these certifications as an expert only last for a period of 2 years is what's been stated today, and then it's been stated now and the court's been newly informed that this 2-year period had elapsed, then I don't believe it's appropriate for the court to make a finding that this gentleman was an expert on the date when he administered this testing. And so therefore I'm going to reverse my prior ruling and I'm going to make a ruling that due to the lapsure of the certification of the vintage 2022 of this deputy, that this deputy no longer qualified as an expert in either administration of or interpretation of HGN testing on October 31st, 2024. And accordingly, he's not eligible then to offer expert testimony. He is obviously under 701.
Y'all need to apologize to her. Y'all need to apologize to her.
And as acknowledged previously by the defense, perfectly capable of offering his own observations and his own impressions of those. But for this purpose, now, presumably since the expert tested, well, that's a finding, we're on the record. So let's move forward. Okay, with that, I think we've completed then the motion. I'm going to grant your motion then, or what's the formality here? I'm going to grant your objection. Okay. So we'll do that next in the record. And then would anyone like a brief break before we launch into a preliminary hearing? We're only 13 minutes behind the scheduled start of that, but or we can.
But do you need to, or?
I'm fine.
I think
Do I
Ms.
go
Ganner
ahead? Do I
requests
say-
a brief break.
Okay. All right. Why don't we take a 10-minute recess? Would that be enough for your comfort? Okay. All right. Thank you all. Yes. So for purposes of this motions hearing, you're excused. You could be recalled, of course, as a witness in the preliminary hearing, but just
You will be.
for good housekeeping purposes, and I don't see anyone else, but if there is anybody else you intend to call that might be on live stream, the sequestration
123.
order would be in place. Okay. All right. Okay. With that, let's go off the record for 10 minutes. Thank you.
We don't have any more of this. That's a different case. That's a different judge.
This is of this motion.
So I thought that was good. I thought all of that was good. I know it was a little boring at first, but we got there in the end. We did. Peg leg, dear, are you doing okay? Breathe. Breathe. Oh, that's pretty. I wonder where that is. Anybody know where this is? Look at that. I feel like I should know what this is, but I don't. But maybe you guys do. Somebody will point it out. Is anybody an expert on photos? Because if you can't tell me where this is, you're not an expert on photos. Breathe. Does it? Does that look like something? Oh, I just figured it was like, I don't know, France or something. All right. All right, time for Fleischer. I'm just looking for him. He's here somewhere. There he is. One of these are him. This one? Yeah.
In New York and Ferris County, Texas. A traffic stop was conducted. The officer requested identification and the defendant provided a
Lovely.
TDCJ inmate card with the name Dang Nguyen. The officer ran that name and came back to have some multiple City of Houston warrants, so placed the defendant under arrest. At JPC, they fingerprinted him through ACES and found that his true identity was Dang Nguyen, and that found he had a felony warrant for yes.
Okay. Mr. Nguyen, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please? See if he has a license.
Fuzzy, I didn't know you knew Spanish.
It was not eligible, Your Honor.
You are not allowed to drive. You do not have a Texas driver license. Do you understand? Unless you have a valid Texas driver license and liability insurance in your name, do not get into a car. You will be signing an affidavit with me today promising you you're not going to drive, Mr. Lynn. I don't care what's going on in your life. I don't care if you have to go save someone and get in a car. Do not drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine, not to mention revoking your bond and putting you in jail. Do you understand? If you want to drive, go get a license, get liability insurance, and then I will happily take this thing off. All I'm asking you to do is follow the law. Do not drive until you get those things and approval from us. That is the only condition that we are going to place on you today, Mr. Nguyen. You have a lawyer because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with Kimberly, and she will tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games or you've taken off, I will issue a warrant. No more PR bonds. You understand?
Yes, sir.
Okay. I'll have you come up here, swear to us that you're not going to drive,
Yes, you've had a surety bond.
and then after that, we'll let you go.
Yeah, surety bond.
Okay, yeah, I mean, and so he also has something upstairs as well. So do you want the same day?
I want to speak for you about that. I think that case will probably resolve this case, so.
Yeah, but we can put in a day. I
I'm
mean,
gonna do the same day, but I think we push off a little bit later.
it's okay, whatever you want.
Okay.
Okay, Mr. Moon, come on.
Good to see you. How's your
You
day?
too?
It's good.
Wonderful. Always good. Four. Thanks. I would have more if I had more money too. I'm just,
Good to see you, right? I know, good to see you.
you too?
All right, Judge, was that state farm to
Raise your hand. Is your name Henry?
No, just,
You promise to spell it?
Next, council is approaching on page 7, both pages.
hi Elena, you ready? Good morning. Happy Friday. So, Michael Love, come up.
It's two, Michael Love and Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up.
One Michael Love is not enough, guys.
Who's Junior? And you are? The third. The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, officer from dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible burglary in progress, with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both detained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, sir.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, I mean, what is this, Minority Report? You know what I mean?
I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man.
Donald,
Life doesn't
it's
get
on the
easier. You
screen
get bigger,
right now.
fatter, you
I
lose
saw it.
hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the
Knowledge.
right way. Don't pollute. Do you understand?
Sir.
I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Okay, you're good. Oh, yes, absolutely.
State, are we expecting knowledge on those two?
Yes,
Yeah. Thank you.
Hi, counsel. You ready? Hey, of course.
Your Honor, I'm here on Marina Mary. It's an arraignment.
Okay, do you mind bringing it up? Are you here for Mr. Bresson?
Yes, sir.
Yeah.
Yes.
Okay. Good morning, Miss Mary. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Your Honor, on Sunday, February 23rd, 2025, officers observed a
What does apology mean? I don't understand, Michael.
vehicle hit a curb median while traveling eastbound at the 10,500 Almeda Genoa Road in Harris County, Texas. A traffic stop was conducted. The officer smelled a strong odor of an alcoholic beverage on her breath and observed her to have glassy eyes. The defendant admitted to drinking the 1 tequila sunrise alcoholic beverage. SMSTs were conducted. It was a 6 out of 6 on the H but they transported her to JPC for the other test due to rainy weather and the defendant wearing heels. She then at JPC refused the rest of the SMSTs and blood warrants.
Okay. Miss Mary, I'm going to find that there's sufficient probable cause to go forward with the case. Have you run her to see if she has any priority to be honest and if she has a license? Please. Miss Mary, I'm going to, like I said, find probable cause. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using either, I will revoke your bond, put you in custody. Do you understand?
He is eligible if he is necessary.
Great. As long as you have a valid liability insurance in your name as well as the license, you may continue to drive. If you do not have either, then you may not drive. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. Don't pick up any new case. All right? For now, I'll have you sign a receipt with Victoria. We'll have you get with Felicia for your bond conditions, then you're free to go, man. All right?
Thank you.
Thank you.
All right, Judge, next is case 2. Please, come on up.
You said page 4?
Page 2, cool.
Good morning, Mr. Cooley. Mr. Cooley, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. So.
On February 21st, 2025, an officer observed a white Nissan Sentra without a front license plate. A traffic stop was initiated. The officer made contact with the defendant driver. The officer observed the odor of marijuana. The defendant admitted to having a cigar blunt with marijuana inside the vehicle. A probable cause search was conducted. The officer observed an electronic scale in the front driver's side door panel, a full cigar with marijuana inside tucked near the passenger seat and center console, and a large plastic bag containing approximately 1.06 ounces of marijuana on the passenger floorboard. The officer found a box of sandwich-sized Ziploc bags and one separate Ziploc bag containing marijuana residue. The defendant was identified with his Louisiana ID.
Can you run him to see if he has a Texas driver license, please?
Yes, Judge.
Mr. Cooley, I'm going to find that there's probable cause to go forward with your case. So the only condition I'm putting on you at this time is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Sir.
If you do not have either, then you are not allowed to drive. And I'm making that a condition of your bond. If I find that you do, then I will put you in jail. Do you understand? Do you have the ability to hire a lawyer or would you like to apply for a court-appointed lawyer?
My lawyer.
Okay, I need you to fill out an application for me to see whether you qualify. So Deputy Echigoin is going to give you an application. I'll have you fill it out. I'll take a look at it. Do not leave until you sign our bond conditions, though. Do you understand? Okay,
So nothing is copied.
so you do not have you don't have a Texas driver license. So you're not allowed to drive. This is an affidavit that you're going to be signing with me today. I don't care what's going on in your life, Mr. Cooley. I don't care that you have to go to work. I don't care that the baby has to go to the hospital. If you don't have a license and insurance, do not drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will scream with joy taking this off for you. But until that point, don't. All right, I'm gonna have you swear to us that you're not gonna drive. I'll get you to Victoria for your sign your reset, and then Deputy Echigoin will give you an application. All right, please.
All right, Judge, next is page 4, Gutierrez.
Raise your right hand. Is your name Luan Cooley? Yes. This one's from.
Oh,
Not
I have
not
a
in
lawyer
Pennsylvania.
online, so
We would
I
get
guess next
busted.
Leonard is the last name. For the defendant, Leonard. Bottom of 6.
Okay.
You are Rachel Gutierrez.
We're all
Ms.
waiting for
Gutierrez,
that
you're
to
charged with
happen.
driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you now.
On February 23rd, 2025, at approximately 3 o'clock in the morning, the officer observed a vehicle fail to signal lane changes twice and disregard traffic control devices, changing lanes over solid white lane markers, and then return to the lane it was already in. The temporary tag that the defendant had on her vehicle was expired as of January 17, 2025, and was voided. The officer continued to follow the vehicle, and the vehicle repeatedly failed to drive in a single lane despite another vehicle in front of it. The vehicle was also clocked traveling 60 miles per hour in a 50-mile-per-hour zone. A traffic stop was initiated. The officer made contact with the defendant driver, and she was identified by Texas driver's license. The officer observed red, glassy eyes and the odor of alcohol emitting from the defendant's person. The officer also observed the odor of marijuana emitting from the vehicle. The defendant admitted to consuming 2 beers and admitted to smoking a blunt while driving until the officer pulled her over. The defendant stated she was headed north, and she stated she was headed home, but her home was in the opposite direction as she was traveling. SFSTs were conducted. 4 out of 6 clues observed on the HTN. 4 out of 8 clues observed on the walk-in turn.
It depends if you're talking about the car or if you're a nurse. Because if you're a nurse, expired is way worse.
2 out of 4 clues observed on the one-leg stand. The defendant consented to provide a blood specimen.
Okay, any prior DWIs and can you?
No prior DWIs, and her driver's license is eligible.
Okay, Ms. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming either, I will revoke your bond, put you in jail. No more PR bonds.
Okay.
Do you understand? Ma'am, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
Fine.
Okay, Deputy Miranda is going to give you an application. I'll have you fill out an or sign a receipt. Victoria will get police you for your bond conditions, and we'll take a look at your application.
Okay.
Please.
All right, Judge, next is page 6. Council's approaching
Mr. Evans.
Leonard Marcus, come on up.
Good morning, Your Honor.
Hey, how are you?
I'm great, Judge.
Here we go. I got Mr. Leonard coming up.
Thank you, sir.
Stuff on the bed. Down right here.
All right, you are Marcus Leonard.
Yes.
Mr. Leonard, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Just so you know, you're not here alone. Your lawyer is here with you, but on Zoom as opposed to being in person. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay.
On February 21st, 2025, in Harris County, Texas, officers met with a complaining witness as a walk-up.
Wait, hold on a second. Do not talk. Okay.
Officers met with the complaining witness as a walk-up. Complaining witness stated that on February 19th, 2025, he and the defendant with his father stated that they were discussing who was stronger and that they eventually felt disrespected by this. Complaining witness stated that the defendant then pushed him into a bathtub and then told the complaining witness to leave. And when the complaining witness was grabbing clothes, the defendant pinned the complaining witness and struck him in the eye, causing an orbital fracture.
So it's son. So I see that he's a prior assault. Same complaining witness?
The one from 2008?
Yeah.
No, I don't believe so, Judge.
Okay. Have you ripped or have you spoken to the complaining witness in this case?
Yes.
What is his wish?
No comment.
Okay. Did you hear that, Mr. Evans?
Yes, I know Mr. Leonard very well, 20 years. Very familiar with the situation, so I understand completely.
All right. So, Mr. Leonard, I'm going to find that there is sufficient probable cause to go forward with your case. It appears that a protective order has been issued on the 22nd of this month. I would get to know it. If you do something to violate this protective order, then the state can and probably will file a violation of the protective order. It's one of the worst cases you can pick up. Do you understand? I am also ordering you as a condition of your bond not to have any contact or not to be in possession of weapons. If I find that you have contact with the complaining witness in this case, likewise, I will revoke your bond, put you in jail. No more PR bonds. Now, you've got a great lawyer because you have one. I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr.
1v1
Evans. He'll tell you
Let's
if and when you
go.
have to come back to court. So do you mind filing no contact in the weapons, please? So for now, I'm going to have you go to Victoria, sign a reset. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Do not leave until you sign our bond conditions, though.
Thank you, Judge.
Hold on, I need to get your date.
No, we already got it
Oh,
yesterday.
you
I
got
came
it?
by yesterday.
All right, have fun, man. Have a good weekend.
Thank you, sir.
All right, Judge, next is page 8. McKelvey. Trying to see that difference.
Hey, Brian, about your guy,
He hasn't been brought up yet.
still no. Do you think we'll get him?
Maybe.
Tell you what, Fozzie. I was in the shower 3 days ago and the hose broke. Right? Wait, I'm getting there. Hold on. So, I'm trying to fix it. I fixed it enough that it worked enough. So I get off work tonight. I go straight and buy a new shower head. So I get up to the bathroom and I cannot get the old shower head off. I cannot. I'm trying my hardest. I'm pushing as hard as I can. I cannot get it off. So, if you can get my old shower head off, then you can be stronger than me. Hurry up. Let's go. I need to take a shower.
Are you, can you be here Monday? If we don't get him today, can you be here Monday?
Yes, and I think that's what we're anticipating.
Can you be here
I told
Monday?
Chief, told the court, I think the plan will be to roll into Monday.
Okay.
Find out. This, you may recall, this is the issue, this had the competency questions. The gentleman who we did competency order, he'd been sent out of state to Louisiana. We did get that back. It had some issues and he was on a 90-day mental health PTI. So there are some issues and I need to see what state he's in, so.
And I just have some concerns now about.
Obviously, because it's number 4.
And if he's not going to be accepting DDRP, I mean, I think it's leaving us with very little options here. And I just can't do the options.
So you want DDRP?
Well, I don't think DDRP is acceptable.
What do you think?
Well, we did a TRAS before in order to see about that. The
Did they-
TRAS, during the TRAS, they said, well, it's hearing voices, so we can't really continue T-Rex. And then their recommendation was we can't accept them in our DDRP because there's been a history of aggressiveness with the staff. And so we tried to go that route and just didn't find any available kind of resources. And so that's where we thought, well, maybe the best resource is a mental health PTI. And that's where things were at until, at least to my knowledge, until I got that email.
Okay,
So,
I guess we'll roll it to Monday and we'll figure out.
yes.
I'll look at it and speak.
Yeah, okay.
Okay. Thank you, Judge.
Thanks, Frank. You are Ms. McKelvey.
Yes, sir.
Ms. McKelvey, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 21st, 2025, officers observed a black SUV traveling northbound on the Gulf Freeway at a high rate of speed at 98 miles per hour. The registration was expired as of February 2024.
What was it?
A traffic stop was conducted and the officer detected a strong
Uh-oh. I don't know what's going on. Hold on. They moved a little bit. Did you see that? Oh, no. Oh, they're back.
Ollisville Drive in Harris County, Texas. The officer observed the black Dodge Charger parked at an intersection when the light was green for motor vehicles to proceed forward. The officer utilized his horn to get the driver's attention, but did not get a response. He then made contact with the defendant, who was the driver and sole occupant, and observed the defendant to be asleep while the motor vehicle was operational at the time of the offense while his foot was on the brake. The officers were able to open the motor vehicle through the front passenger door to turn off the car and observed red bloodshot eyes, slurred speech, a strong odor of alcoholic beverage, and chunks of vomit on the defendant's shirt. The defendant denied consuming any alcoholic beverages and stated that he was coming home from work. The SFSTs were conducted. It was a 6 out of 6 on the HGM, a 3 out of 8 on the walking turn, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results are a .140 and a .141. He was identified by his driver's license.
Got it. Any other prior DWIs and
No
license?
prior DWIs and his license is eligible.
Got it. All right, Mr. Rios, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming any, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Yes, sir. Now, because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you, you pick up a new case. You're a danger to my community. I only have one place for you. Do you understand? Yes, sir. For now, I'll have you go to Victoria Sign and Reset. We'll have you get with Felicia for your bond conditions, and after that, you're free to go.
Thank you. I'm ready to accept.
Yes, ma'am.
All right, Judge, next is case 14, Torres, come on up.
You're Ms. Torres Rodriguez. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to be silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On Saturday, February 22nd, 2025, officers were dispatched to a theft call for service at the target at 22165 FM 529 in Harris County, Texas. The LPO advised that the defendant was observed on video placing items in her shopping cart. She then went to a different aisle and began placing those items in her purse. The defendant then exited the store past all points of sale with those unpaid items inside of her purse. The reportee then escorted the defendant back into the store and had the defendant empty the stolen merchandise from her purse. The total value of the item stolen was $469.92.
Got it. Okay, Ms. Torres, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any target whatsoever for any reason. You understand?
Nice,
If I
Donald.
find that you go to a target or if you
Hi,
pick up a new
Crystal.
case, I will revoke your bond, put you in jail, no more PR bonds. You understand? You mind filing that? No going to any target, please. Do you have the ability to hire a lawyer, ma'am? Would you like to apply for a court-appointed lawyer? Or what would you like to do? Okay, I'll have you go to Victoria Center Reset. I'm gonna have you take a seat in the jury box while we'll get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Hey, Jay.
Yeah, Jen, yeah.
All right, Judge, next is page 15, Vasquez, come on up.
You are Erica Vasquez.
Hello, sir.
Ms. Vasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Donald. Thank
On
you.
February
Thank you.
23rd, 2025, officers were dispatched to the 23,900th block of FM 529 Road in reference to a major accident. The officer made contact with the paramedics who were providing care to the defendant and stated that the defendant required transport to the hospital due to complaints of pain and high blood sugar levels. The witness stated he observed the defendant still sitting behind the wheel of the vehicle when he pulled over to assist her after seeing the vehicle stuck in the ditch. The defendant stated she failed to maintain a single lane, which caused the vehicle to go off the roadway and enter a ditch filled with water. The defendant admitted to drinking 2 bottles of Smirnoff and was observed to have red glossy eyes and the odor of alcohol on her breath. The defendant was transported to the hospital. The officer observed an open 24-ounce twisted tea can, which was cold to the touch in the center console.
So drinking while driving?
Yes, Judge. SMSTs cannot be conducted. The blood warrant was signed and executed.
Valid Texas license? Ms. Vasquez, I'm going to find that there's enough probable cause to go forward with your case. I am now taking away your privilege to drive. You are not allowed to drive for any reason. Do you understand? If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to.
Yo. Excuse me, Judge. Was he an expert? We need to know. Does he have a binder?
Drive. I don't care what your reason is. There's no justification you could give for getting in the car and driving. Do you understand?
So,
He does have an eligible driver's license. Your Honor.
Yeah, please have a phone call on it. Any prior DWIs?
No prior DWI, Judge.
This is the affidavit that you're going to be signing with me. This is a court order that you promise you're not going to drive. Do you understand, Ms. Vasquez? I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to randomly test you.
Debbie.
If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. No more PR bonds.
Oh no, Debbie, I think you're on a second account. Are you on a second account? Because if you are, you just bought another membership. Unless
Do you have the
changed your
ability to
name.
hire a lawyer, or would you like to apply for a court-appointed lawyer, ma'am?
I have a lawyer.
You already have a lawyer.
Yes.
You hired one, or you're going to
Yeah,
go?
I hired one already.
Oh, Judge, I guess it's just signed on.
So what we'll do is we'll just have you take us, well, first now, I'm going to have you come up, swear to us that you're not going to drive.
Hi,
And we'll
Walter.
get you to Victoria, sign a reset. You will get with Felicia for your bond conditions, and then we'll just have you wait for your lawyer and back. Okay?
Judge, that's it for now. The other ones are waiting on their attorneys before we can follow them.
Okay. Counsel, you need her book.
Yes.
He's only something that you're not operate a motor vehicle without a valid check and all of that, and she knows how state that. You don't sound reasonable.
Sorry.
Go ahead and sign for your research.
Mary, Marina, it's right here.
Ready?
Yes, Judge.
Hey,
Good morning. How are you?
hey, what's new?
I have an off docket. Is that okay?
No problem.
Okay. The cause number is 255-2517. This is for Brandon Brown.
Okay.
I am not his counsel on the misdemeanor case. I'm his counsel on the felony case. I was informed from misdemeanor counsel that we wanted to put him
Oh, she works upstairs, guys.
on the docket. He's on the docket Monday here because he didn't have a felony bond. And so,
We want to, no, I think that
right? Okay.
we wanted to,
Like figure out what was happening in felony.
no, and here, because he just picked up a new case. He's on bond for at least one case with us. So we're going to put it to speak about his bond situation. That's
Yeah, so I just came back from felony. I was appointed on Tuesday. He did not receive a bond that day because he was on a parole hold. And then that,
parole hold now.
no, it was lifted that same day that I was appointed. We couldn't tell because, I don't know if you remember on Tuesday, like all the defense attorneys were kind of locked out of the internet and I couldn't check. So anyway, parole hold's lifted. And so on Monday, we put him on for Monday in felony to get a bond there and probably, hopefully resolve it that same day because the case is old.
Oh, really?
Yeah, it's from 2023. So just wanted to make misdemeanor aware,
Is that going to swallow this one up too, you think?
possibly, possibly.
Get the cost number?
Yes,
Is there a global offer?
there is no global offer, Judge. So he's got the 3 misdemeanors here and the 1,
He has one, two.
He has 2, but
He has
You see.
2 evadings and a PON, from what
I've got no PC, I think. Or is it still open? Have you guys not?
it was discharged, no PC. It's not dismissed yet, Judge.
It's not dismissed. Okay. So yes, technically, I mean, well, there's nothing that I can do with that. I mean, that's right.
Right.
So,
So just wanted to make the court aware. I don't know if y'all want to put it for Tuesday.
okay. I have to let Ms. Strong know too. I don't, are we expecting?
I emailed her.
Mr. Smart here?
I think he came up with
Okay.
Yeah, he's back there.
Okay. So I don't know, maybe we'll see her. But yeah, we'll put it on Tuesday. That's
Okay.
fine.
And then if we resolve it Monday, we resolve it Monday.
Okay, did you get the cost number?
I can.
Smart.
No, we're talking about, I was just curious about Mr. Smart.
Oh,
Let me give you the cost number. You ready?
okay.
It's 255-2517. And then there's 2 cases for you to move.
2517?
Yeah.
Okay, what are we doing?
Just on Tuesday, 3-4. Both cases, please. Okay?
That's all I have, Judge. It was good
Have
to see
fun.
you.
You too?
I just put 2 bond petitions in here.
Okay.
Thank you. Yes.
I like it, Walter. I like the little beard. And I only called it a beard right now because people who have real beards get really mad when I say beard.
And you're attacked and you're.
You want to have you sign 3 documents? For the children, yeah. Are you sure? Like if it's, say. Starting Monday.
Hey, Carl. Ready?
You want me to have Robinson brought out? The boy from yesterday, we carried over from yesterday, he was here with his
Yeah,
mother.
yeah, I want to speak to him.
Okay.
Yeah.
I didn't know if you wanted to sit over there for a little while or.
That doesn't matter.
It doesn't matter.
I mean, I don't want to keep you waiting.
Yeah.
You know?
Okay.
Yeah, if you don't mind having them bring him up. Mr. D, I'm sorry, not Mr. D. Mr. Butler. I was thinking Mr. Dixon for a second, but
Thanks. I have Mr. Flynn on the docket this morning for arraignment.
okay, you ready?
Yeah. Mr. Flynn?
Lynn. Oh, Finn.
Yeah. Yeah.
Finn, yeah. Good morning, Mr. Finn. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 22nd, 2025, at approximately 11:07 p.m., an officer was dispatched to 59 Northeast Cross Timbers on City Street. The officer observed a vehicle run a red light, take the exit, swerving in and out of lane number 2 and cross 3 lanes of traffic, almost striking a guardrail. A traffic stop was initiated. The officer observed the driver to have bloodshot eyes, slurred speech, and the strong odor of alcohol upon his breath. The officer had the driver and the passenger exit the motor vehicle. The driver consented to SFSTs and the defendant performed them. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The defendant was read the DIC and consented to provide a breath specimen. The results were 0.141 and 0.138. The defendant advised he had 1 drink while at a bar, and he was the owner of the vehicle, and he was identified by his Texas driver's license.
Any prior DWIs?
No prior DWI, Judge.
Valid license?
Valid license.
All right, Mr. Finn, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Just keep my city safe. That's all I want. You understand?
Yes, sir.
I'll have you sign a receipt with Victoria. We'll have you get with police for your bond conditions, and then you're free to go.
Thank you, Your Honor.
Right this way. All right, counsel, we're looking at April 29. There's all those conditions in the sound of this.
I don't think I'm ever gonna have grandkids. Anthony might want kids, but my girls do not want kids. I don't know why kids are such a joy. I couldn't say that with a straight face. All right, guys, we did it. We made it to the end. I know I didn't do OJ yesterday, but I can't do OJ today. I got some work to do. I gotta fix my bathroom, and I don't know how long it's gonna take, and I have to work a double today. So I'm gonna go fix my bathroom and go into bed for a little bit and go into work. I'll do extra OJ tomorrow, I promise, because it's Sunday, and I'll have time. We'll do extra OJ to catch up. Thank you so much for coming out. Thank you for the super chats and the gifted memberships. I really, really appreciate it. I will see you all tomorrow. Behave today, okay? Bye, guys.
Got this life that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Street of tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh